Welcome back, folks. Just a couple of redirect questions, and then that was it for this witness, Seth Stoughton, and that was it for the day. And it could be it for the state's case. So the jury has been excused for the day. They will come back tomorrow expecting to hear the defense case. Although the state has not officially rested, why bother? You know, think about it overnight. Maybe something comes to you that you want to squeeze in. That way you don't have to make a motion to reopen after you've already closed or completed your case. So with me now, Krista Ramey out of Los Angeles, our trial attorney, and Bernarda Villalona is also joining us, former senior homicide prosecutor. Thank you, ladies, for being here. Quite the witness to wrap things up, Bernarda. You know, he almost didn't testify because there was a motion this morning by the defense that his testimony would be cumulative. I think he was the sixth witness to talk about this use of force. But man, he took advantage of his time. He was on there almost 3 hours. Thoughts?
Absolutely. I mean, they brought this witness in to tie up everything that has been discussed since day one of the trial, from opening statements all the way to now, because we're on week 3. So the purpose of this witness, aside from bringing in his expertise, it's pretty much to recap everything that has happened because 2 weeks have gone by. In addition to that, to provide expert opinion to a reasonable degree of professional certainty that the actions by Derek Chauvin were excessive, unnecessary, and definitely beyond the norm of police practices. And if that is the case, then Derek Chauvin on May 25th of 2020 acted with the intent to cause bodily harm to George Floyd and therefore caused the death of George Floyd and therefore is guilty.
You know, I think that's an interesting argument because the intent issue is the only one that matters for that level 2 murder charge. You have to have had the intent to commit the predicate felony, in this case, the assault. We'll see how the prosecution plays that, because every witness who put out an opinion on the use of force never used that word. You know, they talked about the unreasonableness, but never used that word. Let me ask you, Krista, because this is how the judge interpreted this witness when there was a fight by the defense to keep him out. The judge actually said that, you know, I think it is cumulative, and I don't know if he is worthy of bringing in. Let me see if I have the exact quote here for you. Because he did limit this witness as it related to replaying some of the audio from one of the body cams where there was a question about whether Mr. Floyd said, I ain't had no drugs or I ate too many drugs. The judge said, no, this guy is not going to testify about that, but he was allowed to testify only to the standards and practices. He did say that, I think the state has made its own bed. I have a concern. This is cumulative. I'm not going to allow you to go into the crowd effect as part of his testimony. And yet, Krista, they did go into that as part of the testimony. What do you think about that?
Well, I think the judge specifically limited the prosecution to talking about this particular crowd size. So I think that that's where they were able to go into it. I think because they weren't talking about the crowd size and how that will affect a reasonable police officer, I think that was the line that the judge drew. Because I remember some clarification after argument this morning on how far they could go. But I will say, I thought that the LA police detective sergeant that testified was much more effective use of force. This is the witness they're ending on. He was you know, smart, academic, but also a little dull, a little cagey on cross. I don't like the fact that he wrote an article, an op-ed piece about this case, you know, back in May of last year, right after it happened. You know, knowing that, the prosecution should have gotten that out on his direct examination. So I think that it was just a bizarre way to end the day, I think, for the prosecution here.